Good afternoon. Thanks so much for joining us for December's eLearning Collaborative webinar. This is Laura Kowaleski. Of course, today we're talking about implementing policies and procedures to assure confidentiality. So before we dive in, we sent this resource out via email, but we just wanted to remind everyone that our branch, in partnership with the National Center for Youth Law, and Rebecca, who's on the call with us today, just launched this free online course that has really great information about the specific laws and exceptions within the laws around minor consent and confidentiality. And the training is specifically intended for clinical settings and a variety of staff in those settings. So please consider taking it if you haven't already. Share it widely. And throughout the presentation today, if you've already taken it and you have any feedback for us on how it was, please drop that into the chat box because we'd love to know. So without further ado, I'm going to hand it over to Rebecca, our speaker for today. Rebecca Gudeman is the Senior Director of Health and a Senior Attorney at the National Center for Youth Law. She has run NICL's Adolescent Health Law Program for almost 20 years. She started her legal career providing legal services to youth attending school-based health clinics. And in 2016, she received a national award from the Society for Adolescent Health and Medicine. So welcome, Rebecca, and I will hand it to you.
Thanks so much, Laura. I just turned on my video so you can wait to see how well everyone is doing in terms of knowledge on minor consent and confidentiality and the practices that you already have in place. So right now we'll go through some of the rules, but I think it's sort of a refresher, and I'm hoping that you will chime in with questions or examples so that we can sort of enrich the conversation. But just in terms of what we're going to cover, we're going to go through the rights related to sexual and reproductive health care for adolescents, including confidentiality, talk about some of the strategies that you can put in place, which you've already been implementing, which is super. And then resources where you can go for continuing information. Just to sort of set the stage, I know, again, I'm speaking to the choir here, but we know that confidentiality and being able to provide the option of confidentiality is critical to both whether a young person comes in the door for care in the first place, what they choose to say when they're in that room with you and or in that room with you and the parent, and even whether they come back. And we have decades of research sort of attesting to this. Just one study we wanted to present for those who haven't seen this before. This took place in the Midwest. They went into a number of federally funded family planning clinics into the waiting rooms and interviewed adolescents and basically said if there were some sort of a parental notification requirement that would let your parents know that you're here, how would that impact your willingness to be here or seek services? And 40% of the young people said that they wouldn't be coming in for services. When they were asked, well, what's that going to mean for your practices, 1 out of 5 said that they would simply not use prescription contraception or rely on withdrawal method. And only 1%, though, said that they would stop having sex. So we know that confidentiality has a huge impact on service delivery. And, you know, basically adolescents are like all the rest of us. And particularly when we think about what is a normal part of adolescent development, it is in adolescence that we start to develop that separate identity and sort of independence and learn to take responsibility for ourselves. And it is appropriate that we are helping young people foster that kind of independence and responsibility for their own health care. That said, it is really important to flag that while confidentiality and the option to keep things confidential is critical for young people, many youth will choose to involve their parents. And if we go back to this slide, you'll see that while 40% of female adolescents choose to seek sexual health services without parental or caretaker knowledge, that means 60% do want to involve their parents. But the critical thing is that they want to have that choice, that they can choose whether to involve their parents or not. So parents still play a really important role, and we can bring parents in while we're still promising confidentiality and ensuring those young people who really need it can get it. And that's why, as you all know, we have all of the major medical organizations recommending that we provide that space for confidential care to young people. Okay, so what does that mean? If we actually look around the United States, every single state has a package of laws that allow young people to seek a range of health care services on their own consent. And exactly what those laws say is a little bit different state to state, but they exist everywhere. And in fact, in California, we've had these laws on the books since the 1950s. So this is nothing new. Actually even before the 1950s in some cases. And in general, we can divide those package of laws into two different categories. Laws that allow minors to consent to health care based on the minor status, their situation in life, and laws that allow minors to consent to care based on the type of service that they're seeking, because we think that access to that service is so critical, and that confidentiality and the ability to access it on their own may end up being a barrier if we don't offer it. So let's look first at California's status exceptions. So in California, a minor can consent to their own health care pretty much as would an adult if they're emancipated, and emancipation means that they've gone to a court and received a court order that emancipates them, saying that they can legally be treated as adults for most things. It doesn't mean that they can drink under 21, but you know, they can sign contracts, they can rent apartments, they can get jobs, they can consent to health care. So court order, if they're married or divorced, if they're in the armed forces. And those are the only things that emancipate someone here in California. Otherwise, if someone meets these three criteria, they also can consent for their own health care. So they're 15 or older, living apart from their parents, no matter the duration of that separation or whether their parents have agreed to it, and that they're managing their own financial affairs. And managing your own financial affairs doesn't mean that you have a source of income that's sufficient to be self-supporting. It means whatever income you have coming in or whatever money that's coming in, you're making decisions on how to spend that money and controlling the money. Now, depending on the type of clinic you're in, these status exceptions may play an important role or they may not. If you're in a clinic that sees a lot of homeless young people, for example, these criteria will be really important and may be very relevant. And depending on how frequently you have clients who may qualify to consent based on their status, you may choose to implement protocols or procedures to help identify young people who meet these criteria. So for example, if you're a clinic that is specifically targeted to homeless youth, you may develop some sort of a questionnaire to see if a young person is emancipated or meets these three criteria to consent for their own care. It's important to know that California law doesn't require a young person to present written documentation that they meet all these criteria. Not a lot of us carry our marriage certificate in our back pocket. You know, there's no way to demonstrate on paper that you are living apart from your parents. But your clinic may choose to adopt some sort of policy or procedure in conjunction with your legal counsel to manage risk and confirm that someone meets this. That may be as simple as having them fill out that questionnaire and signing it under penalty of perjury, but again, it's up to your clinic and working with your legal counsel to make that kind of decision. Now, most young people will not fit one of these status exceptions that allow them to consent to any and all health care, and that's where we look at our service exceptions. So let's just start with another quiz. You already did one, but let's just take a second and, oh, the slides are getting all wonky on me. I'm not sure. There we go. Okay, so California, minors of any age can consent to contraception, pregnancy testing, abortion. They cannot consent to sterilization, sports physical, eye exam, flu vaccine unless they meet one of the status exceptions that we just reviewed. And if they're 12 or older, they can consent to HPV, Hep B, HIV PrEP, or STD testing. So let's just walk through. We'll go through each of these and make sure you all are able to point to the actual law that supports these answers. So first, for sexually transmitted infection and sexually transmitted disease, California law, and again, this has been on the books for probably 50 years, a minor 12 and older who may have come in contact with a sexually transmitted disease may consent to any medical care related to diagnosis or treatment, as well as to the prevention of sexually transmitted disease, and this includes any STI that's listed, or any communicable disease that's listed with the Department of Public Health as a communicable disease. And this includes HIV and AIDS, but we additionally have laws that specifically address HIV just to ensure that minors are able to access these services on their own. So these two laws allow them to consent to testing and treatment and prevention. Contraception services, a minor may receive any kind of pregnancy-related care on their own without parental consent, and this is one of the few statutes that has no minimum age requirement. So minors of any age may consent, and this includes contraception, prenatal care, birth, postnatal care, and abortion. And abortion is additionally protected by our Constitution, our state constitution, which is why we've listed it separately. The one exception is sterilization. If someone is under 18, they cannot consent to sterilization, and in fact, a parent cannot force sterilization on their child. So there's a lot of process that you would have to go through to sterilize someone under age 18, and there's no need to go into that here, but we just wanted to flag that that is one of the few exceptions. There are other minor consent laws in the state. We'll point you to some resources if you want to just double check some of those, mental health care, drug treatment, etc. At the end, we'll point you to those resources. But this captures our sexual and reproductive health consent laws. It's important to note, well, actually, let's just say, as a summary, minors aged 12 and up can seek any of the services we just referred to, and of course, there's no age minimum for the pregnancy-related care, contraception, abortion. That means you do not need parent or guardian permission to provide the service, and in fact, cannot demand that someone have parent permission or notification. And this is true no matter where services are being provided. Sometimes I get asked, well, if we're in a school-based health setting or if we're in a FQHC, do the rules change? And in this case, they don't. There sometimes can be some different confidentiality rules, but in terms of consent, sort of walking in the door, those don't change. It would hold true no matter where you're providing the care. So let's do another quiz. 17-year-old Emma has come into your clinic with her baby, and at this point she's asking for a flu shot for both of them and also would like to discuss contraception options. And now what I want you to do is think about the status minor consent laws in our state, not the service laws, and tell me, can she consent to her own flu shot and contraception? So both services based on the status exception. So emancipation or 15 and older, living apart from family, managing own financial affairs. The answer in this case is we need more information. Status exceptions, as we said, are is Emma married or divorced? Is she in the armed forces? Has she been emancipated by a court? Or is she 15 or older, living apart from her parents and managing her own financial affairs? We know she's 17, but we don't know where she's living. We don't know what her financial situation is. We don't know if she's married. So this is one of those situations where in order to know whether she can consent to these two services based on her status, we would need more information, and that's where something like a questionnaire could be helpful. Let's say in this case she's 17, but she's living at home with her parents who are helping her raise her child. She's not married, she's not in the armed forces, so she does not meet any status exceptions. If she doesn't meet any status exceptions, we have to look to minor consent service exceptions. Contraception is certainly something that she can consent to based on state law that allows minors of any age to consent to contraception, but there's no service exception that would allow her to consent to her own flu shot. So unless she meets a status exception, the flu shot requires parental or guardian or caretaker consent, depending on her living situation. Now, what about her baby? The interesting thing is, even if she's not able to consent to her own flu shot, she would be able to consent to her baby's flu shot because California law says parent consent is necessary. It doesn't say that that parent must be 18 or over. So Emma, who may not consent to her own flu shot, may consent not only to a flu shot for her child, but brain surgery, anything that her child may need. So it's one of these sort of weird flukes of California law. In some states, being a parent or being pregnant might emancipate someone. That is not the case in California, and there's some misinformation out there about that. Okay, let's go to our next case. 17-year-old Frankie is sexually active. After discussions, you want to recommend PrEP to reduce his risk of infection with HIV. May Frankie consent to PrEP on his own? Okay, great. Yes, you all are right. I know that this was something that already everyone had tested quite well and understood, and we just went through this. The main reason actually we wanted to set this up, besides emphasizing the importance of this, is to flag that we relatively recently now have a specific FDA approval to use PrEP with young people under age 18, and we also now have public funding available for PrEP. That was not always the case, but now the Medi-Cal system, Medi-Cal minor consent, can be used to pay for PrEP. That's really important because before that, a young person had to rely on whatever private insurance they had through their parents or public insurance through their parents, and there was traditionally a loophole in the law that allowed room for insurance companies to inform parents about services that a young person may have been receiving under a parent's insurance policy. A little bit later, we'll talk about a law that allows a minor to use their parent's insurance and still have all of their information protected, but having Medi-Cal minor consent available for PrEP is huge and is relatively new in the state. Which actually brings us to confidentiality laws. So what are the confidentiality laws that healthcare providers need to follow? California law says in almost all cases, a healthcare provider is not permitted to inform a parent or legal guardian about minor consent sexual health services without receiving the minor's written consent. And the provider can only share the minor's medical records with the parent with that signed authorization. And that authorization needs to comply with both HIPAA and state confidentiality laws. Now, even though access for parents is strictly limited, it is important to flag that healthcare providers are allowed and sometimes required to disclose certain otherwise protected information about a minor to third parties. There's a number of exceptions in confidentiality law that allow disclosure of information, whether that's for billing purposes or healthcare operations. But two examples of mandated reporting include mandated reporting of child abuse and public health reporting. Now, just because you are mandated to disclose otherwise protected information to the public health department or to child welfare doesn't mean that the information loses its confidentiality and is suddenly open and available to parents. But it is important that your clients understand that when you say something's confidential, it's not absolute, and that there are exceptions. And we'll talk a little bit more later about how to help explain confidentiality to your clients. But we thought it would be helpful to just do a quick review of child abuse mandated child abuse reporting vis-a-vis sexual abuse, because there often are so many questions and concerns about what, if you start to ask about sexual activity, is that going to end up triggering any reporting laws? So let's just do a quick review. Our state Child Abuse and Neglect Reporting Act, California Child Abuse and Neglect Reporting Act, requires healthcare providers, when they have a reasonable suspicion of child abuse or neglect, to make a report to either law enforcement or child welfare. We also have what sometimes are known as TERSOF duties that are ethical obligations that may require you to make a report or inform someone when you have a client who you think is either hurting themselves or a serious risk to themselves, or may hurt somebody else and be a serious risk to them. Let's dig into that definition of child abuse. In California, sexual abuse is defined as sort of three categories of information, and I'm sorry, I have a fire truck going by below. It's sexual assault, which means any kind of non-consensual sexual activity. That may be rape. It may be sexual intercourse that occurs when someone is so intoxicated that they are not able to provide consent. Sexual exploitation, which includes trafficking of young people, pornography. You can find more detailed information and definitions in resources that we'll provide at the end. And the third category, our state law defines certain disparate age sexual acts as child abuse based on the age difference between the two individuals involved, even if they themselves say that this was voluntary or consensual sexual activity. Hopefully many of you have seen this chart. We've made it available in the files section here, but this is sort of an attempt to capture the disparate age reporting obligations. The orange boxes are the situations in which you would be required to make a child abuse report based on the age of your patient and their partner, and based on age alone, whether or not they say that this is consensual activity. And the boxes that are white, where it says CJ, CJ means clinical judgment. So in those situations, you would make a report if you believed that there was any sexual exploitation or non-consensual sex happening, but you are not required to make a report based on age alone. So let's just use two quick examples. Let's say that your client, your patient, is 16 years old and comes in to see you, starts talking about her 19-year-old boyfriend and the fact that they've been engaging in sexual intercourse. If you look at this chart, you'll see that in the grid, 16 and 19 brings you to the white box, clinical judgment. So as long as there is no information being provided to you that suggests that this is coerced or non-consensual or that is in some way exploitative, you are not required to make a child abuse report. But now let's say that this was a 15-year-old client who's talking about her 21-year-old boyfriend. In that case, when someone is 15 and their partner is 21, even if they tell you that this is consensual, voluntary sexual intercourse, you would be required to make a report based on age alone. Now, often when we go through this, there are questions about that last chart, because people know that there are certain acts that are illegal in this state, sexual intercourse with someone under 18. But it's really important to remember that as a healthcare provider who is bound by HIPAA and state confidentiality laws, you are not required, and in fact you are not able to report illegal activities unless they fall within the definition of child abuse. So you may find out that one of your clients is using an illegal drug or smoking cigarettes. Both of those things would be illegal, but neither of them is considered child abuse, and therefore is not something that you would be required to report or should report. And in the same way, there are certain sexual activity you may hear about that is perhaps illegal, but unless it is considered sexual assault, as in non-consensual assault, intercourse, sexual exploitation, or disparate age sex, then it isn't reportable. Do I need to, and then as we noted before, this is, even if it is something that you need to make a report about, let's say we have that 15-year-old and the 21-year-old, that you need to make a report, that doesn't mean that the information loses its confidentiality. So you would not be able to let mom and dad know that you've made that child abuse report unless your client gives you that authorization allowing you to share. Now, the police or child welfare may end up informing mom and dad because they're under different confidentiality laws than you are, and they're allowed to. They're not allowed to say who made the child abuse report, but they're allowed to say that they're investigating it, but that doesn't mean that you can without permission. I see a question asking if there's a statute of limitations on reporting. Yeah, that's a great question. So let's say you have a 19-year-old patient who comes in to see you and says, 2 years ago, when I was 17, I was raped. There are some states that very explicitly put a statute of limitations on reporting, so that their state law says you must report any suspicion of child abuse or neglect that has occurred within the last 3 years, for example. California does not have that in the statute itself. It doesn't say you have to report things that happened within X number of years. And so how you determine what that statute of limitations is on reporting is to a certain extent up to you in your practice. There are some folks, for example, therapists, who say, you know, I'm working with a 30-year-old who's telling me about stuff that happened when he or she was 5. It would be really impractical for me to have to report literally every client I have coming in. The argument for reporting things that happened a long time ago, though, may be that if the abuser is still out there and potentially abusing somebody else, even if they're not harming your client, if they are a risk to other young people, it may be worth making that report. So the answer to your question is I can't tell you explicitly sort of what that time range would be, and that's something that in your clinic you have to make a decision about, or as an individual reporter, you have to make a decision. Okay, the next case, well, let's walk through it and then we're going to frame it. So in this case, provider Patty hears commotion at the front desk and walks up. The clinic manager says, Patty, we need your help. There's a woman at the front desk saying she's going to call a lawyer if we don't give her a copy of her daughter's health records right now. Patty goes up to speak to the woman. The woman says that she found some paperwork in her daughter's drawer with the clinic's name on it. She wants to know whether her daughter has ever been to this clinic, and if so, what her daughter said and what services she received. She actually has her cell phone in her hand and says she's going to have her lawyer shut this clinic down if they don't tell her what she wants to know ASAP. So we put this here not because this happens all the time. In fact, it's very rare for it to happen, but it is a really common fear. And it's helpful for your clinic to know and understand how to respond, even if this is a really rare situation. And one reason it is so rare is if you've put in place the policies and protocols that we're talking about that help develop sort of that partnership with parents, this kind of situation can be avoided. But so what do you do in this kind of situation? The law is easy in this case. If you are providing reproductive or sexual health services, you cannot tell mom anything, even that her daughter is a client, without getting the daughter's written permission first. And that's where we say it's so critical to feel really secure in the law and know your patient's rights and know your own rights. Because that gives that grounding in what you're doing. But this isn't a discussion about law. This situation with mom is about that relationship with her child and understanding where she's coming from. So in these kinds of situations, this is the advice that healthcare providers have created. This is not from me. Don't become a participant in an argument. Diffuse an angry situation before it escalates. And really work on prevention through preparation and partnership. And by that, we mean the things that you all are already talking about. Sending that letter when your clients turn 10 or 11 saying your child is starting to enter their tween and teen years, and this is when we're starting to help encourage that responsibility and independence. Making sure that there are posters in the clinic waiting room and in the clinic exam rooms that help explain the value of encouraging that kind of responsibility, that this is a standard practice for you to provide confidentiality. It's not because we think your child has a problem. It's something that we do for everyone. There's a lot of wonderful tools available in the NQIC resource library with sample letters and posters. There's also a number of wonderful tools that you can share with parents and with your clients on confidentiality and the important role of parents in helping their child develop that independence in a toolkit called Understanding Minor Consent and Confidentiality in California, which is, I believe, a link in your files. So how do we actually implement all of this? Here's a couple key strategies to walk away with. Standardize alone time with adolescents regardless of reason for visit. It's not because we think your child has a problem. This is something we do with everyone. As noted earlier, this is easier said than done given some of the framing, and it may not be possible all the time, but if people understand it's a standard practice, then that makes this a lot easier. During alone time with a provider, make sure that parents aren't right outside and can't hear. That's also why we would recommend music or other ways to ensure privacy in the exam room. Provide parents with those resources early on before their child may need those services so that this doesn't come as a surprise. Review conditional confidentiality with each patient during alone time. You may have talked to them about confidentiality and the few exceptions like mandated reporting when you first met your client, but odds are that they're not going to remember that when they've come back next year, and it may be that when you talked about it that first time, they weren't having sex, so they weren't really paying attention. But now that they've come back today, maybe something happened this last weekend, so when you talk about confidentiality and the exceptions and mandated reporting, it's going to resonate for them in a way it didn't before. So to the extent that you can continue to point to those tools and posters and review this however quickly you need to each and every time, it can be really helpful. providing that routine training for all staff on a regular basis, and now we have that wonderful online webinar to make this easier. And then facilitating confidential billing. As we noted, there's a number of public funding streams available that can protect confidentiality and allow minors to create their own, sort of be their own insurance owners, so that parents won't receive explanation of benefits or other information. And then, as I noted, if someone is on their parent's insurance and there is no public alternative available, there is now a law that allows the minor to contact the insurance company and request confidential communications and request that the insured not share information with the owner of the plan. You can find out more about that on the website myhealthmyinfo.org. And I think